Thanks. Thanks, Molly, for coming in and the other guests. Just a number of questions, probably mostly aimed at you, Molly. How do you define a forensic mental health facility? What's the definition of that? Because I've just never heard of being called forensic.
Yeah, well, I mean, my understanding, and my colleagues can come in in terms of the exact legal definition, but my understanding is it's essentially, I think of it nearly as meaning criminal. It means someone who's gotten caught up in the criminal justice system and is now in the mental health sphere. So there's a distinction made between the kind of mental health services of someone who has not apparently committed a crime, and then people who, because of their mental health, or because it's thought of because of their mental health, have committed a crime, and then we basically place them on a different track within the forensic mental health facility. And in terms of the terminology we've used for the report, we talk about forensic mental health facilities, but the only one is the Central Mental Hospital. It is the only designated centre under the legislation, but it is also an approved centre similar to other centres throughout the country. And I suppose the difference from my understanding is that obviously the Central Mental Hospital has that higher degree of security and control. So, you know, as we've kind of said in the foreword to our report, you know, it's not surprising that this report is quite challenging and quite complex, actually, because it's sitting at the direct intersection of two very complex systems, the penal system and the mental health system, which is essentially why we wanted to do this report, because we get asked a lot about mental health. And to date, we've really focused in our advocacy and in our kind of commentary around, you know, the mental health the waiting list for people awaiting transfer from the prisons to the Central Mental Hospital. But we hadn't really engaged deeply with what actually happens in that next stage, even though that's actually part of the prisoner's journey. And if we're concerned with people in prison, then we should probably be concerned with the forensic journey as well.
Right. And what would be the definition of somebody that is deemed unfit to plead?
Well, I understand there's a legal definition, which I'm sure Eilish can come in terms of the exact legal definition, which is probably the best approach rather than me just giving it anecdotal evidence. Eilish?
Sure, yeah, and it's in the Criminal Law and Sanity Act, and it sets out a kind of a number of criteria. Essentially, it's where the court, so that's a judge or the person's solicitor or the prosecuting team, determine that the person can't understand the process due to a mental disorder, or you know, isn't in a position where they can instruct their solicitor, or would essentially, it's where the fair trial rights would not be vindicated for the person due to the fact that they just can't fully participate. But I do think it's important to note that it's not, you know, in this situation, we're assuming that the person essentially has no agency almost, because they don't, it's not something you raise yourself, it's something that's raised by other people. And it means that essentially your degree to which you have a choice in this process is incredibly limited.
And I'm guessing in certain circumstances that the person that is in this situation has committed some pretty horrendous crimes.
Yes, I mean, I think sometimes that is the case. I suppose what I would just want to emphasise is that because of, I think in particular, media reporting and coverage and what most of us would just hear day to day, we are very aware of the most serious crimes, but actually there are a lot of people who get caught up in this system, and it's for very, very minor offences. And that's perhaps, I mean, it's concerning for everyone, but it's perhaps even more concerning when you think about the fact that some of those individuals may end up in the CMH for very long periods of time, when the actual sentence that they would have received is, you know, less than 12 months based on the law if they've been convicted.
Right. So obviously the people that you're speaking about, say minor crimes, if it was a case they were in, say, Mountjoy or Wheatfield prison, they would spend a small short time. But if they're in the Central Mental Hospital, they would spend multiples of that.
Yeah, well, they could, yeah.
They could, on the basis, because they're on the judgment of the courts that they're not fit to plead.
Yes, exactly. And that's a really kind of, and again, it's this kind of slight lack of transparency. You can't point to figures or the numbers of people who are actually caught up in this. But, you know, there are examples, I mean, and this is a slightly different issue, but there were media reports, you know, about probably 18 months, 2 years ago, of an individual caught up in prison who was very unwell but was on remand and ended up spending such a long period on the waiting list for the CMH and actually was in prison longer than they would have been if they had just been processed and convicted of the crime that they were accused of. So that's a slightly different issue, but it's just, again, this kind of, there's all these kind of slightly strange things that can happen where someone can actually end up being detained for much longer than I think any of us would think is actually possible. I don't know if my colleagues want to come in and just on that point about the unfitness and the minor crimes. Eleanor,
Yeah, just to say, sorry, Eleanor, just to say that this, as I said, there were 24 hearings in 2020-21. 7 of those related to people who were facing charges in the district court. So, you know, it is, the other 17, it just says other courts. So again, unclear if it's the circuit court or if it's the central criminal court. But yeah, just to point out that while we are talking about a range of crimes ranging from, you know, up to the most serious, you know, there are people who are facing charges for what would be, it would be possible to plead as a misdemeanor in the district court, but then because of this fitness to plead regime, you end up with this scenario where the person essentially, because they're deemed not fit to plead, then they're deemed unable to decide to have it tried at the district court level, which is this sort of scenario where then it makes it, you know, it elevates it up to circuit court level, and it just, and we actually had a case, and it's cited in the report of that exact scenario. So this isn't like a hypothetical. So it just creates these odd legal scenarios.
Yeah, I was just going to mention that case as well, which I think where the person was being charged with theft, for example. So, like, again, not all of these are very serious crimes or like the most serious or, you know, violent crimes or anything like that, even though that might be who comes to mind when we talk about forensic settings. And certainly that's not the experience of everyone who is detained in that setting. So it's important for us to remember that too.
So there is situations where somebody has, you know, committed a relatively minor crime that could be in a facility such as this for years on end, because obviously their capacity is compromised in some ways, and the state feels that because they don't have capacity, they will be incarcerated indefinitely. There are cases like officers such as this.
That can happen, absolutely. I suppose the rationale or the justification for detaining people while they're unfit to stand trial is intended to treat them in order to make them fit to stand trial. So that is kind of the theory of what should be happening. But as we can see from the length of time that people might spend there and what stakeholders told us during the research for this project, that it may be a long time and people are still not being found fit to stand trial despite undergoing treatment and being in the CMH for long periods. So the goal of the system is intended to be to treat the person so that they can then stand trial. But again, the treatment is not always going to have that effect, and it may have other effects. And again, that's the problem. So the rationale for keeping them there is that we are going to provide this treatment, and once you've had this treatment, you're going to be in a better position to understand what's going on. You're going to be able to participate in the trial. But we don't even have data on how many people then are fit to stand trial, found to be fit to stand trial and go ahead into a trial process after being treated at the CMH. So we don't have that information.
Yeah. Just my final question is in relation to recovery. And that's probably, obviously if people are in this, institutions or facilities like this, obviously recovery and rehabilitation is key to the, I suppose, reform in relation to, and obviously there's a gravity of why people are, incarcerated in the first place, and that kind of, I presume there's a full spectrum of that, from relatively minor crimes to crimes that would be very kind of the serious nature. So in terms of recovery, if somebody commits like the most serious crimes of our laws around murder and so forth, what's the terms of recovery? Because obviously if somebody commits a murder, they spend at least 10 to 15 years in prison, in jail, whatever. But obviously in situations where somebody is deemed, unfit for trial, in circumstances like that, where first of all, where's the recovery kind of basis, and does that person, then realise, look, they weren't of sound mind when they committed that crime. They are now. They're completely compos mentis, and where does that kind of I suppose paradigm end and begin in relation to that person that has may have not wasn't of sound of mind when they committed that crime, but now with doctors and so forth, they've deemed that person relatively fully recovered and of sound mind. I know everybody's different, but just yeah.
Yeah. Well, I mean, again, my colleague may have more insight into the specifics on kind of the mental health. I think it's a really good question, a very big question actually, and I do think some of the things that have come out from this report that have made me think is it kind of challenges how we think about punishment and what we're doing, because there is situations, I imagine, and it can arise where someone has perhaps committed a crime when they were not, by legal definitions of sound mind or whatever phraseology you want to use for that, and then even by the time that they get to their trial and maybe are found not guilty by reason of insanity, they are of sound mind. I'm using that term just as in terms of kind of how we might describe it in the law, and yet we still will end up in a situation where those people might end up being sent to the CMH even though they actually may have recovered. And I think there are examples within the report, and I just might be able to draw on those a bit more, of some people commenting on situations where someone may have been on bail on the offence, and then they go to court and then they're sent to the CMH, but they've been on bail and been completely fine for 2 years and been getting help and treatment in the community, and then they're sent to the CMH, and I suppose there's a bit of a question mark over, well, if they've already recovered, then why are they being sent to the CMH? And that's what I mean about the questions around punishment. It's actually, are we actually doing it because we have to do something if someone's committed a very serious crime and we can't possibly just let them out into the community? Well then, okay, fine, but that's actually something quite different than saying that we're doing it for their benefit and to treat them. So I think that's kind of a slightly a big question. And then I just wanted to say, in terms of recovery and rehabilitation, an issue that has come out, I think, in the report and that we would definitely be aware of is, and Ellen has pointed to it, is the lack of resources within the community for that kind of support. So, specifically, you can talk about step-down facilities from the CMH. From my understanding, that is a big issue with the capacity to date. Now, the new CMH has a new intensive care rehabilitation unit with 30 spaces, which is welcome. And I know Eleanor may have slightly, that is still a coercive system, but it is a more welcome system from my perspective in terms of it would get people out of that very confined situation and back into the community. But again, that's only got 30 spaces. So that's welcome, but it's probably not going to address those capacity issues and actually provide the kind of support that's needed within the community to properly get people living freely within the community with those supports. And I think it's a bigger question, and what the report kind of points to as well is this idea that if we keep focusing on the institutional responses of prison and the CMH, we're never going to redistribute those resources to the community, which is where they actually could possibly be more effective. So it's quite a big thing to achieve, but I think that's kind of where the report is in terms of recommending where we go.
Yeah, just to add to that, I suppose the term recovery isn't used in the Criminal Law Insanity Act, so it doesn't really form part of the decision about whether someone is going to be released from the CMH. So, we might talk about that colloquially, and we might kind of have this understanding that people should be released if they're at the point in their recovery that would make sense. But that's not actually the legal standard that justifies whether they're going to be released or not. And as we've spoken about in this session, and as we've seen in the report as well, the view of the clinical director really is very critical to any release, including leave and other kinds of temporary release from the CMH. So it's not as straightforward as that person recovers and then they're released. That's certainly not the experience that we've seen through the stakeholders that we've interviewed from this research. But it does raise those broader questions as well about accountability and responsibility in terms of how we want to address the fact of what we do when people may come into contact with the criminal justice system at times when they may be in a mental health crisis, or for other reasons related to their health or well-being, they're not in a great place in their own lives. And I suppose I do want to be clear, though, again, we're talking about people having, again, colloquially in this context, having committed crimes. If someone is deemed unfit to stand trial, there is no finding that they've committed a crime, because by its very nature, they're unfit to stand trial. So therefore, they have been charged with a crime for sure, but they're never convicted of that crime. They're just found unfit to stand trial. So I think it's important to be clear, and accurate ourselves. So if that trial actually did proceed, perhaps the first person would be found not guilty. We don't know. But we need to be careful that we don't assume that finding of unfit to stand trial means that there is a finding that the person has committed a crime, because that's, legally speaking, that's not accurate. So it's just really important that we're clear on that. I don't know if Eilish, you wanted to add more in terms of the recovery or kind of what happens based on capacity.
Yeah, I was just kind of thinking about it kind of goes to the heart of the issue is in this idea around so people who are found not guilty by reason of insanity, that first bit there, not guilty, is this sort of recognition. This is what the law is doing, is to try and recognise that for due to a mental illness at the time, the person was not, I suppose, fully. I suppose the law has determined that they shouldn't be held fully responsible, and that's due to the Criminal Law Insanity Act sets out they didn't know the nature or quality of the act, they didn't know what they were doing was wrong, or they couldn't stop themselves from doing it, and so I suppose the idea is that it's what we're doing here isn't about punishment. I suppose it's to do with essentially. The reason why it's to do with, I suppose, helping people to recover in the sense that they wouldn't go on to commit further crimes, or that they would be in a position where they would be, able to live in the community with whatever support they need. So yeah, I just wanted to make that point.